So, next we're going to discuss fee splitting, non-lawyer ownership, and impermissible law firm names. So of course, first off, I'd like to point out that as a supervisor, you're responsible for putting systems in place to ensure rules compliance for all your subordinates, including non-practitioners. It's entirely permissible to allow your paralegals, secretaries, and so forth to go ahead and file submissions without you being aware of what they're filing. And keep in mind, as a subordinate, you're not responsible if your supervisor provides a reasonable resolution of an arguable question. Now, you are, as the supervisor, responsible for non-practitioner misconduct, where you ratify the conduct of your subordinate non-practitioner, or you know of the conduct but fail to mitigate it. Regarding fee sharing, you can only share legal fees with non-practitioners with the representative of an attorney who is deceased or disabled, non-practitioner employees in the case of a profit-sharing retirement plan, or a nonprofit who is referred to your business, who refers your business. Now, keeping in mind, of course, that that pretty much limits all conventional investing. Ownership of any firm that engages in any practice of law by a non-lawyer is prohibited, and non-practitioners may not exercise any managerial control of the corporate level. Non-practitioners may not have any control over a practitioner's professional judgment, and law firm names may not be false or misleading, and may not include the name of a practitioner holding public office. You cannot claim a partnership unless it is factually accurate. So once again, Ben probably couldn't be a partner there. And in an interesting recent case, the firm Jacoby and Myers, who you may be familiar with, challenged the ethical rules against non-lawyer ownership. They alleged that they were representing a class of low-income citizens and that these class members' First Amendments were violated. Essentially, their argument is that the cost of representation would be decreased by non-lawyer ownership and investment, and the fact that the rules prevent this investment means that the class members are currently disadvantaged in their rights to petition the government, which is First Amendment right. Do you have any thoughts on the subject? Are there any advantages to non-lawyer investment or ownership?
Sure. Capital investment.
I mean, everybody likes money, right? But, I mean, of course, the bar has traditionally been very opposed to any sort of non-lawyer investment or any other practice of law by non-lawyers, because there's the risk that lawyers will be subject to undue influence or encouraged to bend the rules to make a profit or what have you. Frankly, I'm not clear on Jacoby and Myers' point about how investment would reduce the cost to the clients. I mean, the purpose would still be to make money after all.
Interest?
And does their profit margin somehow go up because they have non-lawyer investors? I don't see how.
The only thing I can say is if the investors provide enough capital, they don't have to borrow money from a bank. What their collateral, I couldn't even imagine.
Right, and I would imagine that the interest rates demanded would be higher than what the bank would provide.
Yes.
Okay.